My Lords, may I first of all congratulate the noble Lord the Minister on retaining his place in the recent reshuffle. May I refer also to the speech by my noble friend Lord Kirkhope of Harrogate, which I thought was fascinating, and it may be that as a result of that speech and the points made by him, and to some extent by the noble Lord Greenway, the Minister would now prefer today to withdraw this statutory instrument on the grounds that the Department has probably miscategorised it as being properly falling under maritime law, and come back with an instrument that acknowledges the richer context in which hovercraft are used, and increasingly used, and, if we are to believe my noble friend and the noble Lord, who have some expertise in this, likely to be increasingly used in the future, so that the statutory instrument can be pertinent and robust and what is called future-proof. And if so, we would completely understand why he wished to withdraw that, and we would not object to its withdrawal. The updates in the instrument are largely technical, it must be said, but there are a few points I'd raise. First, on fees. We must be anxious that fees are set at levels which are prohibitive for operators of hovercraft. So I would ask the noble Lord if there is some limitation on fees, for example, a limitation which requires that taken together over a period, say, of a year, the fees in total do not exceed the costs of actually delivering the regulatory service, the cost to the Department or the Maritime and Coast Guards Agency of delivering the regulatory service. So at least they cannot be used in a way that interferes excessively with the operation of any services that are proposed. And although the Minister has said there was no public consultation, and he's given a reason for doing that, and that is because the instrument doesn't impose any new requirements, I wonder if the sector, of course, being one company, if the sector was consulted on this question of fees, which, although it is not a requirement, is an expanded power, and therefore exposes the sector to a greater range, potentially, of fees than exists at the moment. So if he could explain whether they were consulted on the fees provisions and whether there was any response, and if they weren't consulted, whether, again, he might prefer to consider doing so before pressing ahead with the instrument today. The next thing is the use of ambulatory references under Section 306A. Now, I have to confess, my Lords, that I had never before come across the concept of ambulatory references. I had to make some inquiries. In fact, in my original query to those whom I consulted, I wasn't sure if the ambulatory power related to the hovercraft itself or to the regulations. I mean, was it the hovercraft that was ambulating about, so to speak? Apparently not. What it is, I think, is what we would know in a different context as dynamic alignment. And it is very troubling because we have got rid of dynamic alignment from the regulatory regime of this country, mercifully. But here we are apparently embracing it, and it appears that ambulatory references or dynamic alignment relates to the regulations made by the International Maritime Organization, and the purpose of this provision is that those regulations would apply directly in UK law without further reference to Parliament or indeed further law-making. There would be neither a statute, primary legislation, nor a statutory instrument for those regulations to apply. And I do find this slightly concerning because we are, of course, in this House very keen to ensure that parliamentary oversight of the making of new law and regulation should be absolutely crucial. So I do think that is something I should like to know. But I think I'm right in saying that this is the only example of ambulatory reference in UK regulatory law. If I'm wrong about that, the Minister can tell me, and I'm happy to be corrected about it. So it is quite significant as a matter of principle in relation to the whole question of parliamentary scrutiny and accountability. Parliamentary scrutiny, I would remind the Minister, I know he doesn't need reminding of this, is the government's friend, because it keeps everybody on their toes when they know that they are subject to questions and examination by members of this House and of the other place. So they shouldn't worry about parliamentary scrutiny in the slightest. It is their friend. I think, therefore, that the government has probably come at this issue, I say this especially in the light of the comments by the two preceding speakers, has come at this issue on a very narrow basis, possibly a flawed basis. And it may be the case that if it's not withdrawn, that it has to be rewritten again quite soon in any event to take account of the expanded use of hovercraft away from a maritime setting. But in the meantime, provided the implementation in relation to the one existing operator is proportionate and involves an appropriate level of consultation, we don't object to the government's intention at the moment.